So in the last video we looked at the nature of a constitution, looking at the general definitions of a constitution, some of the kind of things that a constitution in terms of a state constitution, a constitution that, that organises a government of a state, how they kind of operate, and then we looked a little bit at the kind of different features of constitutions around the world, specifically drawing attention to the United States. In this lesson, we're going to look at the basic concepts of constitutional law, the more theoretical framework behind constitutional law, before we start to look at the sources of the Constitution in the United Kingdom, and then start to delve into the more legal, technical parts of constitutional law. So as an introduction, there are a number of related concepts within constitutional law. We're going to touch upon three main ones here, the three main concepts that are touched upon most of the time, in any kind of constitutional law course. We're going to talk about the concept of sovereignty, we're going to talk about the concept of the rule of law, and we're going to talk about the concept of the separation of powers. Okay, and this isn't going to be the only time we touch upon these three topics. We're going to talk about parliamentary sovereignty in a lot of extensive detail. We're going to talk about different theories of the rule of law very shortly, in fact, and also the concept of the separation of powers. But we're just going to briefly touch on them within the context of the kind of theoretical framework in this lesson. So to start with, let's look at sovereignty as a concept, and effectively what sovereignty means is it is effectively just the ultimate power without limit. Okay, so if one institution has sovereignty over a certain kind of procedure, that means they have the ultimate power to control and to regulate that certain procedure. Okay, political philosophers like Thomas Hobbes, who was a philosopher working around the time of the English Civil War, and Carl Schmitt, who was a political philosopher who was around during Nazi Germany and was actually a member of the Nazi Party himself, argue that there should always be a sovereign. They argue that there should always be a sovereign, that there should be one kind of a person or something like a person or institution that has sovereignty over everything else. And they argue that there must always be someone or something that has the final say on certain situations. Okay, so Hobbes talks about this within the framework of the English Civil War. A lot of his philosophy is influenced by the English Civil War. He's very pro-government, pro-existence of the state, because he was living at a time where it was, not entirely clear whether or not a state was going to exist coming out of the end of the English Civil War. And so therefore Thomas Hobbes' his views on the state and his views on the sovereign, in this case relationship with the monarchy, was very powerful. Carl Schmitt again argues about the existence of there being a sovereign through the context of the ideology that he was around at the time, and a lot of the Nazi Party and Nazi ideology influences Carl Schmitt's philosophy, which it doesn't mean to say that it makes it something that shouldn't be discussed, because a lot of philosophical points, specifically about things like things around the idea of the state, is brought up in the work of Carl Schmitt. But it should be noted that when we're talking about sovereignty need not be a single individual. So historically, sovereignty exists within a single individual, within the monarch, especially in England. Okay, so we've had a monarchy for a very, very long time, ever since the foundations of England and the unification of principalities in England. However, in the sort of terms of British constitutional history in the last few hundred years, okay, the sovereign is seen as Parliament. And we start to talk, when we're talking about sovereignty within the context of UK constitutional law, we're generally talking about parliamentary sovereignty. And parliamentary sovereignty entails that Parliament has the power to make and unmake any law they want. Unmake any laws. Okay, any laws, any legislation. Now, there's obviously, this is the traditional understanding of parliamentary sovereignty, but there are more modern versions. There are more extreme versions as well that talk about Parliament being, sovereign over other states, which is quite interesting. But there are also challenges to this concept of parliamentary sovereignty that we'll talk about in later lessons, things like devolution and our previous membership with the European Union. There also has to be a distinction made between what A.V. Dicey would call the difference between legal sovereignty and political sovereignty, the difference between what is legally sovereign and what is politically sovereign. Now, the context that Dicey understood this to be was that Parliament had effectively legal sovereignty, so parliamentary sovereignty was legal in its context, so parliamentary sovereignty. However, that this legal sovereignty doesn't necessarily extend to political sovereignty. So Parliament has the right legally to do whatever it wants, make or unmake laws. However, whether or not they have a political mandate to do whatever they want is a different question. So, for example, the Parliament has the right to go and vote tomorrow on repealing the Human Rights Act. However, whether or not that would be a very politically popular thing to do, whether they have the power politically to do that, is something that's slightly different to their legal foundational view of parliamentary sovereignty. And again, this is just a very brief understanding. We'll be discussing this in later lessons. Moving on then to the idea of the rule of law. So the rule of law simply just means that it is desirable to have rules known in advance that are binding on government and governed alike. Okay, so binding on the government and the governed alike. There should be rules in place. And this is, a relatively uncontroversial idea. The more contention comes when we start to develop a wider version of the rule of law. If we just leave it here with this, what could be understood as a basic definition of the rule of law. It's relatively, uncontroversial. Rule of law. Generally speaking, the idea that there should be rules that are binding on everybody and everything, that are known in advance, that aren't retrospective. Okay, this is generally seen as a positive thing or an uncontroversial concept. However, this is just a basic definition. There are different types of ways legal theorists and political philosophers have defined the rule of law throughout the years. Okay, a more complex understanding of the rule of law will naturally invoke some kind of certain moral implications and also political implications as well. And this is where it becomes a little bit more contentious. So more contentious over here. And, these ideas, political and moral ideas, come when we start to think about how we're going to implement the rule of law, and we start to implement ideas around the rule of law, things like openness, equality, free and fair judiciary, these kind of things. And there are different interpretations of, what would be described as the rule of law. And again, we're going to look at all of this. We're going to examine this in a series of lessons. There's not just going to be one lesson on this. We're going to be talking about A.V. Dicey's interpretation of the rule of law, who I've already mentioned today, who's a very foundational constitutional scholar. And we're going to talk about, other interpretations of the rule of law, more modern interpretations. And so, this is just a basic idea of the Constitution, a basic concept that naturally is naturally entailed from an understanding of our Constitution. The final thing I want to talk about is the separation of powers. And again, you notice that this isn't in a lot of detail, but like I said, we're going to talk about it in a lot more detail later on. So the separation of powers generally requires that a government should be divided up into different branches of equal importance. Okay. Now, the qualification that it has to be of equal importance isn't necessarily the a prerequisite requirement for the separation of powers. So if we just bracket this here and say not necessarily a requirement. So not necessarily a requirement. And this is because of a number of reasons. Because, firstly, a separation of powers can exist in a situation where, a constitution delineates different types of powers. Okay, and these powers may be different in nature, but also, weighted differently in terms of relative power. Okay. And there's nothing uncontroversial about having one or two branches that are more powerful or more important than a third, but just that they all share different powers themselves. And the idea of them being of equal importance and to ensure that no branch gets too powerful also brings into the conversation the idea of checks and balances as well. So we've got checks and balances. And generally, when we're talking about the separation of powers, we're talking about dividing into three branches of government. And these are legislative branches, executive branches, and judicial branches. Okay, so we've got the legislative branch, which is generally responsible for making laws. We have an executive branch, which is generally responsible for enforcement of laws, so enforcing laws. And then we have a judicial branch, which is responsible for interpreting laws. This is a very surface level understanding, but as we can generally see here. Now, like with most discussions of the basic concepts of a constitution, it's easier to describe and explain it within the context of a different type of system, because our constitution is so unique and so different to pretty much every other system in the world. It's better to draw comparisons to places like the United States, which is what I will be doing a lot in these first early videos, because the separation of powers is a lot more clear cut in the United States than it is in the United Kingdom. However, there have been efforts in recent years to increase the separation of powers. But generally, these are the three foundational principles and basic concepts that we will encounter when we're talking about constitutional law. We're going to be talking about the concept of parliamentary sovereignty. We're going to be talking a great deal about the idea of the rule of law, and we're going to be talking about how the UK government is the powers of the UK government is separated across different branches. And in the next lesson, we're also going to start to look at the sources of the UK Constitution, whereabouts we derive our Constitution from, because as we've already noted, it's not a single written document.